I have been fortunate to solicit Mr. Tom Hennick from the FOI Commission. He is the FOI guy in the state of Connecticut. The last time we had him down, it was a long time ago, it was 9 years ago. 2006, he was a good friend of Ed Hennick. They encouraged me to bring him down. He spoke to us about what requirements are, what our boards and commissions should be doing, chairman, clerks, etc. It was very informative. I'm remiss that I should have had him down since then multiple times because we've had a lot of turnover. So Tom is here. He is the FOI guru. He's the educational guy at the FOI Commission. And he's going to do a little presentation, field questions, so don't be shy.
That's right, don't be shy. We'll try to keep it sort of loose and informal. With the clock at my back, I'm also
There's
cognizant
no
of the fact that you have...
You're not an attorney, right?
No,
there's no clock. There's no clock.
Well, I meant so that they go home and watch Voices.
No, the voice.
So the idea is that we try to give you a little bit of what I call FOI 101. Just some basic things about FOI, not to necessarily beat you up about it, but to answer your questions, to make it something that by the time we're done, you're more comfortable with. How many of you are board members, volunteers? So when you go down to Lenny and Joe's, I know which way, that way, they give you free food, right? They give you a big hug and they thank you for all you do for the town, right? Yeah. I'm not seeing the heads go on in that. Well, one of the problems is when I do these sessions, people say, you don't get it, we're volunteers. We signed up to be on a board to help the town, to do that sort of thing, but we didn't sign up for this FOI stuff. And I get that. For 10 years up the road in Durham, I was a member of the board in Durham where I live. Last 5 as the chairman, and I know what it's like to sort of do your real life job during the day and then you come as a volunteer at night and people are telling you how stupid you are and you don't know what you're doing, and so I get that. But the FOI stuff goes with it. It's part of the law, it's part of what you need to do, and the more you know about complying with this law and running your meetings in a proper fashion, the better off you'll be so that you can concentrate on the real job that you were sort of elected or appointed to do. Before I talk about FOI, let me just tell you a little bit about me. Stole a little bit of my thunder there. I'm not an attorney, and I don't know if you think that's good news or bad. I don't know. Good news. A couple say good news. Well, the reason I tell you that is that when we talk tonight, it's not necessarily legally binding. It's not anything that you can pick up and take to court. Again, it's advice. It's based on, I'm in my 15th year at FOI, and so I have a pretty good idea of what the things are that will take you, again, in the right direction, away from problems when it comes to freedom of information. Now, in the interest of full disclosure, before I joined FOI in 2001, I was a journalist. Is that good news or bad news? Yeah, some say good, some say... Well, the reason that that's relevant is that it sort of gives me a rounded idea. A lot of times at FOI, I spend most of my time on the phone answering questions. People call up with questions or send an email with questions. I can almost anticipate where they're going with it because, before I joined the commission, I was the guy on the other side of the phone, sort of prompting the questions or triggering the questions to the official to ask them, say, gee, do we give this out, or is this meeting an executive session, and what should we do? So I've got a pretty good sort of idea as to what people are asking for, what they want, and what FOI is about to them. And then, of course, my experience as a board member, that sort of completes the circle. I've been on the other side. I've had people, asking me for things through freedom of information or questioning whether or not the executive session we had just called was proper. And again, my board, for better or for worse, had somebody who knew a little bit about FOI. Yours maybe don't. So the idea would be, before we're done tonight, that you're that person so that you can avoid some of the pitfalls, so that you can understand what your obligations are, but also what your rights are, so that freedom of information is something, it's more of a second thought. It's not the kind of thing you have to worry about. Because a lot of people do worry about it. It's a law that can be a little bit complicated. It's based on a concept that should be familiar to everybody. It goes back to the foundation of our country. This is James Madison, mid-1700s. A popular government, without popular information or the means of acquiring it, is but a prologue to a farce or a tragedy, or perhaps both. People who mean to be their own governor must arm themselves with the power which knowledge gives. For democracy to work, people need to know what's going on. So that's a pretty simple concept. Open government, transparent government, that's the way democracy works best. But when you read this law, it sometimes gets a lot more complicated than that. And the reason I think goes back to the founding, when this law was passed 40 years ago. This is 40 years ago, this year the law was passed. And if you do the math, 40 years ago puts us right smack in the middle of Watergate. And if you're old enough to remember, if you studied the mood of the country back then, was very much tilted against government, because government was almost brought the country to its knees when you think about it. Secret government, government behind closed doors, government conducted in a fashion that was not open to the people. And Ella Grasso was in Congress when Watergate exploded all around us in 1973, 2, 3, 4. And she was appalled. I know that for a fact, but I was told, by many who knew her that she was appalled. So when she came back to run for governor in 1974, she said, if I'm elected, we're going to have an open government law. And she made it one of the first planks in her campaign platform in 74 when she ran. And it was after she won, she made it one of the first bills, one of the first pieces of legislation that she pushed through in 75. And one of the things that happened was she said, it is so important to our state that this law will be passed unanimously by our legislature. I want you to think about that for a second. Passed unanimously by the legislature. So she guaranteed a unanimous vote. Have you ever watched the legislature? Can you imagine guaranteeing a unanimous vote? Well, not only did she guarantee it, she got it. I've seen a recording. There's not a single no vote. Now, why is that relevant to our conversation tonight? Because I want you to think about the legislative process. I want you to think about a unanimous vote on a law like this, or any law. There had to be a lot of negotiations in there. A lot of back and forth, well, of course I'm in favor of open government, but that record, maybe I'm not so sure. And maybe for that instance, that meeting should be behind closed. You get where I'm going with that. So there's a lot of areas you look at it. What's that? Right. Intuitively, you're saying, okay, it should be open, but maybe the law takes you in another direction because somebody wasn't comfortable with a particular part of it. Trying to create that balance that gave us a law that works for open government, but also allows governmental entities to do their jobs. So we'll go through this law, and you'll understand, you probably know it already, but as we go through it, that your compliance in many sections depends on your ability to interpret the law, because there are these gray areas created by, sort of these negotiations, these things. It's not black and white. So you have to be able to interpret the law and move in the right direction. Again, thinking in terms of openness and accessibility, but not necessarily following your intuition sometimes. So that's what makes it hard, and that's why these discussions are good. The law is about two basic things. It's about access to public meetings and access to public records. And we'll talk about both aspects of it, and as we go through, I really encourage you to ask questions. Don't save them all for the end. We may hit upon something, you may say, wait a minute, that's not the way we do it, or I don't think that's the right way. Stop, ask, we'll talk about it, and we'll try to clear it up as we move along. One of the first things that happens is people see freedom of information, and they automatically think that it's the guarantee, the carte blanche to come into a board meeting or a town office and say, under freedom of information, you need to tell me. I need to know. It's free information, you got to tell me that. One of the first lessons we try to tell people is it's not necessarily about free information. It's not about answering questions. Have any of you had that situation where people walk in and ask a question and say, under freedom of information, I have a right to law? I bet you have, right? Every day. Okay. Not saying as public servants we don't answer questions, but the law is, let me spit it out, specifically about access to meetings and records, but not necessarily about answering questions. So if you're in a situation where someone says, under freedom of information, I have a right to know, and you either don't know the answer fully or you're not comfortable giving it verbally, you say, you've got to find the record or go to the meeting that has that information. That can be a frustration for a lot of people. They're asked questions and they know that this law says that they have to be open and accessible, but they don't necessarily feel a comfort zone in answering the questions. People see our name, they see freedom of information, and we get some doozies, let me tell you. People think that we are the information kiosk for the state of Connecticut. People call us up at all times with different questions, send me this, send me that. They have this vision of us sitting in this big vault with every record held by every agency in the state of Connecticut, and they just call us up and tell us to send it to them. We have to explain to them that's not what we do. Freedom of Information Commission, which was formed as part of this law, is basically there to adjudicate. When people believe they've been denied access to meetings or records, they come to us. They file a complaint and they say, the town of Clinton has withheld a record, we believe improperly, the Freedom of Information Commission tell them to give it to us. It's a simple explanation, but that's what our commission is established to do. But that doesn't stop people from calling and asking questions. I'll just share one story with you. A couple of years ago, if you're familiar with Hartford, when a play is coming to the Bushnell, anybody go to Hartford when there are plays up there? And the flags hang from the light poles telling you, announcing what's coming. So there was a period a couple of years ago when Mary Poppins was coming and everybody was very excited. Mary Poppins banners flying all over Hartford. So I answered a question to somebody about a meeting notice or something like that. Someone says, Tom, you got another call. I picked up the phone. Woman on the other end says, I'm desperate. I need your help. So what's the matter, ma'am? She says, I need tickets to Mary Poppins. I said, well, no, what? She said, this is freedom of information, right? Where do I get the tickets? And I said, no, it's not that kind of freedom. I just want you to know that I was a good public servant. I looked up the number. I gave her the box office number. I hope she got it. But that's the sort of thing that people think it's about. So the first lesson is it's about access to meetings and access to records. Since most of you are board members, I'll start with the meetings provisions. We'll probably be heavy on that while we present. But I encourage you to ask any questions about meetings or records as we go along. Access to meetings. Let me read the definition of a public meeting. Meeting means any hearing or other proceeding of a public agency, any convening or assembly of a quorum of a multi-member public agency, and any communication by or to a quorum of a multi-member public agency, whether in person or by means of electronic equipment, to discuss or act upon a matter over which the public agency has supervision, control, jurisdiction, or advisory power. Folks, the bottom line is that any time your board gathers to do its work, it should think in terms of having a meeting as far as the FOI law is concerned, which means you need to notice it, it needs to be open to the public, and there need to be minutes when the meeting is done. A lot of people get into trouble with this. Well, it's budget season, right? It's budget season. We're just having a little workshop. We won't worry about FOI. Folks, if you've gathered to do your work, it doesn't matter what you call it. It's a meeting. You need to notice it, make sure it's open, and make sure there are minutes when you're done. Yes?
The notices on the town website are sufficient?
Well, it's a little bit ahead of where I was going to go, but I'll answer the question because there's some confusion about websites. Technically, the meeting notice has to be available in your board's office if it has one, also in the town clerk's office. But the website requirement is only for special meetings. And there's confusion about that because in 2008, the legislature passed a law that said all notices and all minutes have to go on websites. A lot of towns complained. A lot of towns said, wait a minute, we don't have the infrastructure, we don't have the personnel, we're not able to do that. Some of them complained to the point of taking their websites down, which we really found just...
Which we threatened.
Yeah. People were worried about, complying with the law. By the way, that was not an FOI initiative, that was Governor Bell's initiative, and the legislature passed it. Well, anyway, the legislature said, okay, we hear you, and then they passed the law anyway. And so that was the law. Then a couple of years later, they peeled it back for municipalities. So just as towns, cities, boards, commissions were getting used to doing that, they told them, never mind, you don't have to do that anymore. And left the only thing in place required the special meeting notice. Now, one of the reasons that I, spell it out that way is that many, many boards got in the habit of doing it and found that it was much easier to put things on websites because it got the information out a lot more efficiently and a lot more quickly, and they were getting fewer calls, they were getting fewer, questions, letters, where's the meeting, when's the meeting, because it was all right there on the website.
So what is the requirement? Post in the hall and upstairs?
It's got to be, no, if for a regular meeting, it just needs to be available in the town clerk's office and in your office. For a special meeting, you post it and you put it on the website. And we're going to talk about the difference between the two meetings in a second.
I was going to say that.
Okay. Yes?
What's the requirement for the agenda? Is that part of the notice you're talking about?
Yes. Yeah, the agenda, you want to be specific. It wants to say where the meeting's going to be, when it's going to be, and what you're going to talk about. When we talk about a special meeting, the notice and the words notice and agenda are somewhat interchangeable. They're basically the same thing. To get back to people thinking things are not a meeting, they say, well, we've got a full board So we're going to form a little subcommittee, and the subcommittee doesn't need to worry about FOI. That's not the case. When a board forms a subcommittee, the subcommittee becomes a public agency as defined by this law. I didn't read you the definition of a public agency, but in it is the following phrase, including any committee of or created by. So that subcommittee becomes a separate entity and has to follow the same rules. A lot of times boards and commissions say, well, we're going to meet without a quorum, so we don't need to worry about FOI. Now, I got to tell you, that one's one of the more confusing pieces of what we have to deal with. Because there's an appellate court ruling that says if you don't have a quorum, you don't have to worry about FOI. No quorum, no meeting. There's also an appellate court ruling that says if you don't have a quorum, you should still worry about FOI. No quorum, you're still having a meeting. I want you to think about that for a second. The appellate court has given us basically diametrically opposed rulings. One says yes, one says no. So when people call up and say, what do we do absent a quorum? Our advice is always, look, err on the side of safety, because they've told us that in some instances, even absent a quorum, you could be having a meeting, make sure it's noticed, make sure it's open, and make sure there are minutes. Now, many of your boards, many of the towns that I deal with, have charters or have bylaws that say no quorum, we can't meet. I get that. What I'm telling you is that if you choose to go forward anyway, even absent a quorum, you want to make sure that you follow the rules. We had a case just a little while ago over in Woodbridge. There were 3 members of the board when the meeting started. One of them got up and left, and the other 2 declared that there was no longer a meeting, but then they sat there and did board business. Someone complained. They said, no, it wasn't a quorum, it wasn't a meeting. Complaint came to the FOI Commission. The FOI Commission found that the board had violated the law by not producing minutes that reflected what happened, even though they didn't have a quorum. Your brother. Oh, really? Anyway, so we jumped into it a little bit about the different kinds of meetings. The law talks to us about 3 kinds of meetings. It talks to us about a regular meeting, a special meeting, and an emergency meeting. The regular meeting is a meeting that you have for a schedule you submit to your town clerk at the end of January of every year that says we meet on the 1st and 3rd Tuesday, the 2nd and 4th Wednesday, 7 o'clock town hall, 8 o'clock library. Whenever that is, that's your regular meeting schedule. The special meeting is a meeting that you have when you're not scheduled to meet. There's a lot of misinformation about that. People think that special meetings can only be about certain things. That's not the case. Special meetings can be about anything. The difference is this. For both of them, you have to produce that notice, that agenda, that details where you're going to meet, when you're going to meet, and what you're going to talk about. That needs to be available at least 24 hours before the meeting. And again, available. Town clerk's office, your office if you have one. For a special meeting, it also needs to be on a website. When the window closes on that 24-hour sort of deadline, at a special meeting, you can only talk about what's on that notice. At a regular meeting, should something arise that's not on there, you can vote to add it by 2/3 of those board members who are present. That's the fundamental difference between the two. It's not a matter of what the topics are, it's whether or not they're on the agenda. So regular meeting, you can vote to add something, special meeting, you can't.
The topic being, what's the topic new business? That's a pretty broad topic.
Topic new business should not be on a special meeting notice.
But it could be on a
Take it
regular
off.
meeting.
If it's on a regular meeting notice, the chairman says, is there any new business? One of the members says, yes. Not on the agenda, Mr. Chairman, I'd like to talk about topic X. Okay, all in favor of 2/3 vote, you can add it to the agenda. But you should always be careful to add those items, new business, old business, other business. They're not the best things to have on an agenda, but you know, boards don't meet every day. And sometimes things happen between the time that the agenda is prepared and the time of the meeting. You got to bring it up, or the board member's got something on his or her mind that they want to talk about. That's what that's for. But at a special meeting, it's worthless. You should take them off because you just can't do it. Okay?
And that's within 24 hours. Well, 24
After
hours.
24 hours, right.
Yes,
You can change any notice or agenda up to that 24-hour window.
as long as it's a regular meeting. That's
Well,
what's
you can
scheduled
change,
prior
you
to
can change it
January
for a
3rd.
special as well. You can
Prior
change
to
it for a
24
special as well prior to 24 hours. Yep.
But during a regular meeting, I mean, that whole new business, a lot of it is precipitated by what's happening during the old business or reports. I mean, it's very hard to predetermine what new business is going to be
Right.
up until 5 minutes before it happens.
Right,
You know?
right. People are, I guess the concept, look at it this way, regular meetings, people would anticipate that. They have a general idea what's going to be discussed, but they know that things could come up. First selectmen's report, road crew report, finance report, and those sort of things could trigger questions that a board would want to deal with. So then you would add them, just make sure you add them to the agenda. Yes, ma'am.
Could you address the issue of whether or not a caucus is legal? That is-
We'll get to that.
Okay.
We will get to that, I promise you. Yep.
It requires 2/3 though to add?
2/3 to add to the agenda, that's correct. Yep. Now, the third kind of, any other questions? Yes.
About minutes.
Yeah.
So subcommittees, planning and zoning for discuss quite a few subcommittees. When there is an agenda posted, sometimes minutes are verbatim of what the agenda are with nothing further. Is that,
Okay, jump ahead for a second. When we, how many people take minutes? How many minutes takers do we have? A couple of poor unfortunate souls. I need to tell you that I do the minutes for the FOI Commission. And one of the things I share with people is minutes need not be the recreation of War and Peace. They are not every word that everybody says, although sometimes people stand up and make these brilliant speeches and they want every word in the minutes. That's not what's required. Technically, the only requirement in minutes is a record of who votes for what or for whom. So if no action is taken, what you just said could be perfectly okay. The Planning and Zoning Subdivision Subcommittee met, discussed revising the subdivision rules. No action was taken, period, end of story.
But there should be a minute on record. If
There
there's an-
should
if there's
always
an
be
agenda
minutes. There
posted.
should always be minutes on record, even if it's only a couple of sentences. That's correct. And, just back to minutes for a second. You have to find the balance. I'm not suggesting that you just put in a record of votes because you're creating the historical record for your town. So that a year from now, a day from now, 5 years from now, whatever it is, somebody picks it up and says, aha, I know where they were going with this. I know what it was. But you've got to think in terms of a concise, crisp, consolidated summary of what happened, not every single word that was said. You're just asking for trouble when you do that. And it's not necessary, and it's not required.
Tell the police chief all the time, less is more.
Well, in that case, certainly. So, back to the meetings, the third kind of meeting, which I didn't get to, the emergency meeting. The emergency meeting is a meeting that I always discourage boards and commissions from using. It is an unnoticed meeting. Now, I know Willie's sort of filled me in, everybody gets along in Clinton, right? There's no fighting, there's no, at least listen, by the way, I told you I was a journalist, one of the things I covered, I was a sports writer, and I went up to Morgan and everybody was always very happy, covering basketball games. I covered you guys.
Only the girls.
No, actually the boys won the year that I, way back when, George Perron was the coach. Am I dating myself? Anyway, everybody seems so happy, but I guess maybe that's not the case when you're in the town hall.
When you walk out of the gym, things change.
Yeah, okay. But anyway, so you want, the first thing that happens when you have a meeting that's not noticed is what? What are they hiding? What aren't they telling us? Why didn't they notice the meeting? Even if it's a perfectly legitimate emergency, so I always discourage, just sort of on that level, try not to do it. But the second reason, a more practical reason perhaps, is that the bar for what constitutes an emergency is set really high. The law doesn't want you to meet without notice. It wants to encourage meetings to be noticed. It doesn't want you to just sort of have throwaway reasons for emergency meetings. Little story. Over on the western side of the state, Ridgefield, there was a situation where the assistant fire chief thought he was about to become the next chief. He was very excited, he was all happy. Then he found out he wasn't. Got really angry, really, really angry. He stormed into the first selectman's office one Friday afternoon in the spring and started screaming at him. How can you do this to me? This is terrible, this is horrible. I'm told it was one of the best knockdown dragouts that you have ever seen in the town hall. Finally, the first selectman calms him down. He's known him for years. He says, calm down, listen, you can swear at me all afternoon, you're not going to be the next chief. But I tell you what, I understand where you're coming from. We will make you the interim chief while we look for a new chief. He ain't happy. But he says, all right, I guess. Then he walks out. Well, you know how it is in a small town. Word gets out real quick. The phone starts ringing off the hook. Did he really do that? I can't believe blah, blah, blah. Back and forth, texting, emails. Oh, it was crazy. First selectman is being told that this is not a good idea to keep this guy around. He was insubordinate. He was unprofessional. He's a troublemaker. Get rid of him. First selectman thinks about it and says, you know what, maybe there's some legitimate cause for concern here. He schedules an emergency meeting for the next morning, Saturday morning. He brings his selectmen together. He has an emergency meeting. They decide, you know what, the guy's no good. He's fired. Now, it's a Saturday morning in the spring. If the snow ever leaves us, he was out painting his house or something like that. So they send somebody up to town hall. To his house, drag him down to town hall, they bring him in, you can imagine what he looks like with the leaves hanging out of his head and the whole thing. Bring him in, thanks for coming in, you're fired. He gets mad all over again, he says, you can't fire me because I quit. So they reconvene this emergency meeting and accept his resignation. Then he thinks about it a little bit. He says, wait a minute. wait a minute, what was the emergency there? And he files a complaint with the FOI commissioner. That's what I said, if someone believes they've been denied access, they file a complaint with the commission. And he files a complaint and says, look, I had a right to be at that meeting. That was wrong. There was no emergency there. They could have noticed it. So he brings it to the FOI commission, hearing officer, and then the commission agree with him and say there clearly was no emergency there. Remember I said the bar is high, and they declare null and void everything that happens at that meeting. Which means he was fired and or quit in a meeting that basically didn't happen. Okay, now that could be the end of the story, but then it wouldn't be a good story, because when anybody believes they've been wronged by the FOI commission, remember I told you that there's a lot of interpretive nature in compliance here. People file appeals of our decisions all the time. So they appealed the decision of the FOI commission, and it went all the way to the state Supreme Court. And in January of 2010, 5 years ago, the state Supreme Court says, we agree with the FOI commission. Now, I wish I could tell you that happened all the time. We get overturned sometimes. We have to interpret the law too, and sometimes the court says, no, you're wrong. But in this case, they agreed with us, and they too declared null and void everything that happened in that meeting, meaning that he was fired and or quit at a meeting that never happened. So people, what's the big deal? I tell the story all the time to say, you know, think of the adjutant, think of the legal fees, think of all that was going on while they were trying to, get out from under this. Struggling with, things like how much back pay do they owe the guy? There was a rumor going around town that somebody who should have been under his insurance umbrella had a major surgery and he had to pay for it because it wasn't covered because he was, the whole, it's just a mess. So I tell this story all the time and say, look, think before you, and it was Christmas time 2013, so a little more than a year ago. I tell this story, someone's sitting about where this gentleman's sitting, starts laughing hysterically. I said, what's the matter? I said, you think this is resolved? They're still fighting about it. So the actual incident, 2006 maybe, something like that, 7 years later, they're still fighting about it. Last year, about mid-year, I picked up the Danbury News-Times and I saw a little article that said that the town had finally settled with this guy and paid him off.
How much?
I don't know, tens of thousands of dollars. But here's the kicker. Can anybody guess why they finally decided to settle? They were actually forced into a settlement by a judge. Said you can't keep going on like this. The actual incident that we're talking is 8 years ago. Just think of the angst, the churn. Well, they had to settle with him because the guy that they ultimately hired in the first place is now retiring. And guess who's a candidate for the job? All they needed to do was notice a meeting. Get where I'm going with that? Now this is an extreme example of what can happen if you fail to notice a meeting properly. It's not going to happen every time you goof up. But if you're in a position where you're saying, oh, we don't need to worry about it, we don't FOI, heck with it, I want that little light to go off in your head about this Ridgefield story and say, you know what, maybe we could wait 24 hours. People say, well, what is an emergency? We might have one.
Natural disaster.
Natural disasters. When Sandy was coming, there were a lot of meetings for preparation, things like that. In the last year, the last 2 winters, first selectmen look up, another storm is coming, they look in their bin, there's no road salt. Hey, we got to get the Board of Finance and the Board of Selectmen together quickly, we got to transfer some money and buy some more salt, or else people are going to get hurt. There's going to be a safety problem. That's what an emergency is. If you have a situation like that and you need to have an emergency meeting, you have the meeting, you talk about only what that emergency situation is, you make sure that you create minutes within 72 hours that reflect what the emergency was, what board members were there, and what you did about it, and that will cover you on an emergency. Now, just as an aside, because of what I talked about before, unfortunately, it's human nature, people being suspicious. If you have an emergency situation coming up and you can get the word out, the shoreline time still exists, call them. WLIS still on the air? Call them. Just tell people so that it's clear that you're not hiding anything. You've got a real emergency on your hands and you have to have a meeting. Yeah?
I understand the emergency thing, but suppose you're in you're meeting once a month.
Yeah.
And you really want to ramp up your activity.
Yeah.
And you don't, it's going to take more than 2 hours or 3 hours a month. I mean, is there some other segment of just having extra meetings, but they're posted?
Sure.
I mean, do they become hybrids between emergency and, or are they?
No, they're special meetings. All you have to do is wait 24 hours. You can meet anytime you want, any place you want. I got a question today about someone who was concerned about not meeting in town hall. We need to have an extra meeting. We need to have it on a Saturday. Can we meet something? Yes, you certainly can, just so long as it's properly noticed.
You can post it in a private home, people, just even if it's a private home.
I tell people, well, we're going to have a little picnic and have a meeting afterwards. I said, just make sure you have enough food. because everybody's entitled to come. You don't have to feed them, but anybody's entitled to come, and just make sure that it's clear that wherever you're going to meet, people can congregate. You can always have a meeting, it doesn't matter. That's, you got your regular schedule, but the special meeting can be anywhere, any place, anytime, just so long as it's properly known.
And on a special meeting, you cannot put new business, old business, you have to
No,
stick
it'd
to
be,
the
you know,
agenda.
Stick
the
to what's
agenda would
there.
be fine, would be definitive.
Right, got to be definitive, absolutely. Now, remember that your meetings are open to the public. Anybody can come. You don't want a sign-up sheet at the door that says, oh, wait a minute, only Clinton residents, or, you're not from that neighborhood or anything like that. Anyone can audio or videotape a meeting. We have an example going right here. You can't stop it. It's allowed. People ask me all the time, they say, do we have to be told that we're being recorded? Now all these phones that we have these little recording devices. As a former chairman of a board, I think common courtesy should dictate that you would tell somebody, but the reality is the law doesn't. Remember, this law was 40 years old, and it didn't sort of envision the kind of devices that we can now record with. So you should perhaps always assume, for safety's sake, that you have, a possible recording going on, but you should always understand that anybody can do that. Now, it doesn't mean that they can run roughshod over your meeting, run the camera back and forth, stick microphones in people's faces. As a board, you're allowed to have sort of a plan, a policy for where the camera's going to be located, where the microphone's going to be located, so that you can run an orderly meeting. You have a right to do that. Remember that the FOI Act does not, under any circumstances, guarantee anybody the right to speak at a public meeting. Many people think that it does, but it does not. The public speaking portion of a meeting is entirely in the hands of the board, so who speaks, when they speak, how long they speak, is entirely in your hands. Especially at budget season, a lot of boards put together sort of a policy, a time limit, and they have a timekeeper. I know we did. During budget season, everybody wanted to tell us what they felt we needed to know, and we certainly wanted to give everybody a chance to speak, but we had a very strict three-minute time limit. And when the 3 minutes were up, I said, look, I'm not being rude, but other people want to speak, sit down. I mean, I wasn't quite that blunt, but you know what I'm saying. You have a right to do that. You have a right to control how long you want the meeting to go on.
On that note, what if you let some people speak for a long time in the beginning who are presenting? Do you have to be fair and let everybody speak at the same amount?
Well, there's nothing in the law that says that. You would recommend that, but there's, if someone's making a presentation on behalf of the board or on behalf of a plan, that's different than people from the audience speaking. It's in the hands of the board. Consistency is not a bad idea, but there's no law, nothing in the FOI Act that speaks to that. That's why it's not guaranteed. Another question that's asked, people say, well, wait a minute, you said we can't have people sign up when they come in the room, but we have people sign up when they want to speak. Well, because public speaking is not covered by the FOI Act, that wouldn't be a problem. So you can't have them sign up as a prerequisite to come in the room, but you could have them sign up to speak. In other words, it's because it's outside of FOI's purview. So if you had a sign-up list for public speaking, you can certainly do that. There are two paths, two avenues that boards and commissions can take to exclude the public. We're talking about doing everything in public, but again, as they created this balance when they wrote this law 40 years ago, they created two paths. And one of them is going to get to the question that was asked from the back of the room, but we'll start with talking about executive session. Has everybody heard of executive session? You know what it is. Remember that an executive session is a portion of a publicly noticed open meeting. It's not a separate meeting. It's part of a noticed meeting. So even if the only item on the agenda is an executive session item, the agenda says executive session likely planned for whatever reason, the board convenes in public, then votes to go into executive session. Again, a 2/3 vote is required to go in, 2/3 of those board members present. And then in executive session, the board can only discuss, can only deliberate, can only talk about what the topic is, and then it must come out of that executive session to vote, and that vote must be recorded in the minutes. Again, back to the idea of everything. The key requirement is in minutes is that you record who voted for what or for whom. There are 5 specific reasons for an executive session. A personnel matter, pending claims or pending litigation, a security matter, sale or lease or purchase of property, you're building a new school, and you're negotiating with different property owners all over town, you could have those negotiations, those discussions about the appraisals, all those things behind closed doors. The fifth reason is something of a catch-all. It allows a board or commission to go into executive session to talk about the content of a document or documents that it believes are exempt from disclosure. The selectmen ask their attorney for a written legal opinion about a specific item. The written legal opinion is covered by the attorney-client privilege. It's a document they're not going to share with the rest of the world. They go into executive session to talk about that written advice that their attorney has given them. Anybody here on a board that deals with bids or RFPs? Bids and RFPs are exempt from disclosure until you've actually signed a contract or concluded negotiations. So let's suppose you are the police commission and you put out bids for new cruisers and all the bids come in and you want to study them as a commission before you start talking publicly about the different bid alternates and things like that. You could go into executive session and talk about them because those documents, those bids and RFPs are exempt from disclosure. These are just a couple of examples. We'll talk a little bit about records. You'll see there's a lot of different ones that are exempt, but that's just an example. The personnel executive session. First of all, remember that when you notice this, you have to put more than just executive session personnel on your agenda. The law is very clear about that. The courts have told us that. That goes beyond what the FOI Commission says. The courts have said you've got to at least give a clue as to who you're talking about. You don't necessarily have to name the individual. So let's suppose we're going to talk about a town hall employee. Executive session, likely discussion of a town hall employee. You need at least that much. Before you're going to do that, you need to make sure that the person has been given notice. The person has the right to know beforehand that he or she is going to be talked about in executive session. The person then has the right to come forward and say, no executive session, I want that discussion to be held in public. And if the person says that, the board cannot go into executive session because the person is demanding that it be done publicly. Now what sometimes happens is the person comes forward and says, I want that done publicly, and the board knows that it's going to talk about something that the person doesn't want talked about publicly, and says, how about if we invite you into the executive session, you can tell us your side of the story. That's perfectly okay because the law allows a board to invite in whomever it wants to an executive session, to give evidence, to give testimony, not to sit and be a witness, but to be a participant together so that it can deliberate in a more intelligent fashion. So what happens is the board says, well, let's not do it publicly. What if we invite you in and the person says, okay, and waives that public discussion that he or she originally wanted? It's fine. You bring the person in, the person has the discussion, the board finds out what it needs to find out, but then that person has to leave when the board deliberates. You don't ever want to leave people sitting in the audience when you've got a whole room full of people that you've already told you they can't stay because it's executive session. The personnel executive session is one of those that in my mind flies against intuition. If you think about it, you're going to talk about me in executive session, shouldn't I be in the room? Don't I have a right to be in there? But the law doesn't guarantee that. Only the right to demand the discussion be held publicly. Pending claims and pending litigation is pretty much what it sounds like. There needs to be a lawsuit on file, or at the very least a letter of intent to sue. Boards, especially land use boards, get into trouble. They're sitting there, they're looking at a site plan, and they're saying, you know, if we accept this, we might get sued. Let's go into executive session to talk about it. That's not enough. There has to be an honest-to-goodness threat or suit on the table for them to go in for that. It also allows a board to go into executive session to contemplate taking legal action. The ZBA realizes that it has passed, it has voted on a project, and the project person said, the heck with the ZBA's ruling, we're going to do it anyway. Build a shed too close to the sideline, something like that. And they're going to take action to make the shed, get the shed torn down. They could have that discussion behind closed doors. You wouldn't necessarily want to tip off the person you're about to sue or take action against. Yes?
So that doesn't have to be on the agenda, that you're going to go into executive session?
Well,
Or you can add it.
If it's a regular meeting, you could add it, but let's suppose the item is on there. A discussion of Jones property, violation of last month's ruling. And then you get to it and you say, let's do that in executive session, it would be okay. Now, if it's a regular meeting and it's not on there at all, you would first add the item, and then vote it. You need 2 votes. Take the second one to take it into executive session. Yes?
Does it have to be a person? If you go into executive session and talk about a corporation or business, somebody you deal with,
Well, you know, again, it depends on what, if it fits the topic. I mean, if you're taking action against the corporation, you certainly could. Be a little more specific. The personnel executive session is the performance of an individual or a board member. It's not necessarily the performance of a corporation. But let's suppose it's a legal matter with a corporation or a security matter with a corporation, then you could probably do it.
But you don't have to be more specific than pending, say pending litigation.
You want to have a little more than that on there, pending litigation, discussion of legal action against, to protect the town's rights, or
Right.
or discussion
You don't
of.
have to necessarily name.
Well, see, the thing is that sometimes if you name the lawsuit, you're sort of giving
You're
away the
tipping them off.
strategy, and you're
Right.
tipping them off, so
Right.
you could certainly work around it. But
We
you
don't want to say we're going after Grove Gardens, we just want to say we're going after this guy on West Main
But
Street.
that's a good example. I've served in so many, I've been in so many executive sessions where we talked about somebody we have a contract with. Not a legal issue, but we want to talk about their performance or their,
La, 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 la.
That's right.
There's-
In area.
That's probably wasn't legitimate. Probably wasn't the right way to go. It's only, it's employees, it's public officers. Now, if it was breach of contract, then we're going into executive session to talk about possible breach of contract to protect the town's rights. That would be okay. But if you've got a contractor who's doing a crummy job, that's not really a reason, unless you're going to sort of void the contract or something like that. The security executive session is one that never used to come up. But sadly, in the wake of Sandy Hook, it comes up more and more, especially with boards of education. Talking about placement of security personnel, placement of security devices in schools, things like that. You'd want to have those discussions behind closed doors so that, you know, the bad guys, for lack of a better word, wouldn't know where the extra security was, so you can keep your kids safe.
Yeah. On that, not quite with just the schools, we get requests all the time, and this is in the wake of 9/11, with our emergency management plan.
Right.
Now, is that subject to FOI?
Okay.
Do we want the bad guys to know what we're going to do in the event
Emergency
of
management plan, that's a legitimate question. We'll jump ahead. There's an exemption to disclosure in the FOI Act, 1-210B-19, that talks about if you believe that releasing a document would be a safety risk or a security risk, you're supposed to contact the Department of Homeland Security and ask the Department of Homeland Security what it thinks. Okay? Homeland Security said, then they will review the document. So you get your request for your emergency management plan. And in your mind, releasing that is not a good idea because the wrong people will find it, or at least parts of it. I've mostly seen sort of 50, redactions in that regard. You go to Homeland, they say, okay, you're right, don't release it. Then if the person files a complaint, Homeland's supposed to go with you to the FOI Commission to explain why releasing this would be, a security risk.
And we've had requests for that. Been pretty staunch about, no, we're not giving you that because it does,
And there's been no complaints.
thankfully.
People make requests of public agencies all the time. Unless we get a call with a question like that, we don't know about it. We are not the FOI FBI.
Right.
We're not coming down here.
Unless you get a complaint saying we didn't release something.
We only come into the picture if somebody files a complaint. So, the meetings you're talking about, I'm not taking notes and saying I'm coming down. It never happened, right? I'm not coming down here to, in other words, we don't enforce that way. That's not how it works. Any other questions about executive session? Okay.
Is a communication privileged in an executive session?
Is it
Privileged, what is the privilege? In other words, people after they're in an executive session, what can they say about the executive session or not
The
say?
point would be to not say anything. I mean, the whole point of being in an executive session is not to communicate. You're in there, if you're in there legitimately, you shouldn't be having conversations about what you talk about. Now, clearly there is no law that dictates that, and there's some boards are troubled by people who come out of executive session and tell people chapter and verse what happened. But, common sense would tell you if you're in executive session and you're a good board member, you're not going to come out and talk about it. I told you there were two paths that boards take. I'm getting your question now. The other one is one of those that's kind of in the head-scratching department. I read you the definition of a meeting. The sentence in the law that follows that definition about all these open meetings, everything's open, everything, says, meeting does not include. Meeting does not include. There follows a list of gatherings, many of which everybody in this room would call a meeting. But for the purposes of freedom of information, the legislature said you can call them whatever you want. They're not meetings. The top of the list, collective bargaining. Do we have unions in Clinton? Okay. Collective bargaining sessions are not meetings for the purposes of FOI. Now, if you've ever sat in on one of those,
Thank God.
right, you sit at a table, you give them a proposal, they laugh hysterically.
Or yell at each other.
Or yell. Then they'd counter and you laugh hysterically. Back and forth, all night. Are you not there all night sometimes, right? Are you not doing the work of your board when you're doing that? But for the purposes of FOI, the law says that's not a meeting, so it's not noticed, it's not open, and there are no minutes. The term of art that people have taken to using that's not in the law is the non-meeting. Has anybody heard that category? Heard that phrase floated around? The non-meeting. Think about sitting through a 3.5-hour negotiating session and then going home and telling your wife that you've just been in a non-meeting for 3.5 hours.
That's all we're going to do.
Yeah, it doesn't really fly, but that's what it is. So intuitively you're thinking, it's got to be a meeting, but for the purposes of FOI, it's not. Executive level search committees. Superintendent of schools retires. The board forms an executive level search committee to look for a new superintendent. It operates outside of FOI, not noticed, not open, no minutes. If you think about that one clicks in with some sense. You're looking for the best possible candidates for these jobs. And some of them may already have jobs.
Finance director.
Finance director,
Business manager.
police chief, business manager, all those things. So you might get people who already have jobs and they wouldn't want their current employers to know. You brought up the caucus. This is one that's very hard to explain. But the law says that if members of the same board and the same party want to talk, they can talk till the cows come home. Now I want you to think about that logically. We're sitting here talking about open meetings, open meetings. You've got an 8-member board and 5 of them are the same, well, 9 members probably. 5 of them are the same party. They probably will control the flow of what happens. The 5 of them go off and they go to Lenny and Joe's and they have dinner and they're talking and they set everything up, boom, 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 boom. Then they come into a meeting and they clearly have the votes and they basically had the meeting outside beforehand. How does that jive with the concept of open meetings? Well, this was one of the big sticking points before they got that unanimous vote in 1975. People said, shouldn't that be a meeting too? But the powers to be won out. They basically explained it away like saying, well, no, that's really about who's going to bring donuts to headquarters on Saturday morning and where the road signs are going to go and things like that. And they were able to pass that, and the caucus is in there. But it's clearly morphed into more than that, and it flies in the face of what we talk about. But where people get into trouble with the caucus is they forget that it's only same board, same party. Let's have the town chairman come in and talk. Let's have the Board of Education chair come in and talk. And it's different boards, and once it's no longer the same, you're not in caucus anymore, you're having a meeting. So if you're going to employ the caucus provision, be very, very careful. Same board, same party only. Another one that's in there is social gatherings. A lot of people who are new to board say, wait a minute, those are my friends, now I can't have dinner with them anymore. Well, it says you can have a chance meeting or a social meeting, neither planned nor intended for the purpose of discussing matters relating to official business. I get a kick out of that one. What the hell else are you going to talk about? Right? Board members sit there, what else are you going to talk about? All right, look, let's
Fire department banquet.
Yeah, let's not be naive, folks. Let's not think that these discussions don't happen. But what you want to do is avoid setting your budget over the eggnog at the Christmas party. Listen, you're going to exchange ideas, but be careful and be limited in what you do. And this goes to another point that I can't stress enough. When I read you the definition of a meeting, it said whether in person or by means of electronic equipment. Electronic equipment was written 40 years ago for that powerful first selectman who would get on the phone and say, you're voting this way, you're voting this way, you're voting this way, bing, bang, boom. They walk into a full house, 400 people. All in favor, all opposed. All in favor, all opposed. Everybody's looking around what happened. What happened is they had the meeting on the phone before the meeting took place. And you can't do that. And today, 2015, we're talking about a lot more than telephones, aren't we? Emails, text, Twitter, all these things that I can't even comprehend. I'm not telling you to not use them to disseminate information. When's the next meeting? When are we going to do this? I want this on the agenda. Or, I feel very strongly about this. Let's talk about it at the next meeting. But if you see yourself having deliberative conversations, via some of these devices, stop. Because they are potentially improper meetings and you don't want to do that. Yeah,
Just, I mean, setting the agenda is a very important thing of a meeting. You know, if you set the agenda, you usually win the debate. So where are the rules about who sets the agenda besides just the chairman? Establishing what you're going to discuss during this meeting.
the setting of the agenda, how to do it, is not covered in the FOI Act. All it says is that that it is not a meeting, communication limited to notice of meetings of any public agency or the agendas thereof are not meetings.
So you could have 2 or 3 people saying, look, let's get this done in the next quarter, start setting the agenda. And that
I'm
would
talking
be-
about the specific meeting.
I'm talking about a specific meeting, because it actually would carve out the specific meeting to say, meeting 1, let's talk about this.
Yeah.
I mean, that's still kind of,
That would be okay, but when they start talking about why that has to happen and how they should, and they're not of the same party, that's a problem. It's just, I want this on the agenda, we need to talk about this next, let's do it.
Typically, I don't want
Go ahead, sure.
if somebody wants something on a selectman's agenda, they'll send a request to Mary and I. Mary's my administrative assistant. When one of the selectmen wants something on the agenda, or somebody from the public wants to have something on the agenda, they'll send a request.
Right.
And we'll add it or not, or I'll say, well, if you come to the meetings, if it's a selectman or woman, you can request to have it added
so
at
the
the
chair
meeting.
could poll the members. You could send out an email and say, look, meeting, here's my
All right, you
recommended.
deal with the chair.
Yeah, recommended agenda, you guys
want
need to add on to it, that's all.
The chair says, this is what we have on the agenda, and another member says, I want this as well.
Right.
Yeah.
Yes,
Yeah.
but don't get into votes on email.
No,
So on the email, as long as you're just sending a basic piece of information or making a request or telling them the meeting's been moved to Tuesday, anything like that, as long as you're not deliberating an
That's,
outcome.
that's where I believe the bright line is drawn.
Okay.
Now, again, let's be careful here. When you send out, let's suppose you feel very passionately about an issue that your board's about to discuss, and you say, here's my position on this, and it's a nice, meaty sort of explanation of why you feel that way. Somebody's going to read it and say, you're the dumbest thing I've ever, and start coming, you've got to make sure that that part doesn't happen. That's the way we communicate today, folks. I mean, that's what one of the problems is, so you want to make sure that you don't, and if one of those comes back at you, say, stop, we have to do this at a meeting.
In other words, don't take a position.
Don't take a position, correct. Yes,
Moving agenda items around, do they need notice?
not covered by FOI. It's not a problem, not an issue. Any other questions?
In general? What about bylaws for your board or commission?
Bylaws, again, not covered by the FOI Act. Many boards have them. Many boards operate by Robert's rules. Many have charters. But that's not something that the FOI Act has control over.
Do you recommend that we have bylaws?
I would recommend that you have at least a general policy as how your boards should act. I'm not sure about bylaws. Sometimes the bylaws, you get a legal mind involved and they maybe get more complicated than you need. But that's really a decision you have to make as a town. That's not anything for us to really jump in on. I will tell you that as a chairman of a board, I liked having the guidelines that we had. We had specific things that we could or couldn't do, but we were also a regional board. So it was good because we had 2 towns and that was just us. We talked about minutes before. The other thing to throw in about minutes is to remember that they are to be available within 7 days of the meeting. A lot of people say, well, wait a minute, we don't meet in 7 days. We can't approve them, doesn't matter. You want to have your minutes within 7 days because the law says that you must. So what happens if you get changed? Well, here's the way I would do that. You put in your minutes, they're done within 7 days. At the next meeting, the board looks at them and says, listen, we want to change a few things. Someone wants to see the final version, they look at that set of minutes and see what changes were made to this set of minutes. You don't keep changing versions because that gets very confusing. The only time I recommend getting rid of this version, and you actually don't get rid of it, you put another version out, is if the changes made at this meeting make this set so unidentifiable that you need to have both sets to see where they went.
So you don't recommend approving as amended? You don't want to
Well,
make amendments to the minutes?
You make amendments to the minutes, I mean, that's just, how you want to phrase it.
But you can approve those as amended at
Yes.
that meeting?
Yes, you approve them as amended, and then the next set of minutes should reflect what the amendments were. Chairman noticed that
Should you bring them back to the next meeting to have them approved, so the proofs that reflect the
I think
actual
you're gonna, I
changes?
think you just would approve them at the.
All right, I want to make sure.
Yeah, approve them once.
So you don't have to ratify them at a later
No,
date?
I would.
Does that 7 days apply to state commissions as well?
Yes, it does.
And are they required to put it on the website or in that 7 days, or?
Local boards and commissions are not, state commissions are. When the legislature peeled back that law, they left it in place for state agencies, but not for locals. Not required for websites and local.
So when that doesn't happen, what's the redress?
Where's that? At a state level?
Yes.
Someone files a complaint, and the FOI commission, takes it up.
They push it under.
Yeah. I wish. We'd have a lot less business. Any other questions about things relating to meetings before we talk a little bit about records? Anything at all? Okay. I'm going to brief down, in the interest of time, the records provisions, primarily because most of the things you all have to deal with records usually go through staff. As board members, if you've got a request, you probably deal with staff, and so some of the minutiae, some of the particulars you probably wouldn't have to deal with. But let me read for you definition of a public record. I'm going to read it for you in two parts. Public records or files means any recorded data or information relating to the conduct of the public's business, prepared, owned, used, received, or retained by a public agency, or to which a public agency is entitled to receive a copy by law or contract. Whether such data or information be handwritten, typed, tape recorded, printed, photostated, photographed, or recorded by any other method. That would be part one. Part two says, except as otherwise provided by any federal law or state statute, all records maintained or kept on file by any public agency, whether or not such records are required by any law or by any rule or regulation, shall be public records. And every person shall have the right to inspect such records promptly during regular office or business hours, copy such records in accordance with it names a section, or receive a copy of such records in accordance with the same section. I read you the definitions, which basically said that every record held by every public agency is defined as a public record, and in theory, anybody can come in and inspect it or ask for a copy. But on top of those base definitions, there are what we call in the FOI business the 3 E's. There are exceptions, there are exclusions, and there are exemptions to disclosure of records. So now you're looking at me, and your eyes are rolling to the back of your head, and you're saying, why tell us that everything's a public record, that anybody can inspect it or get a copy, and then tell us we got all these E things that say we might not be able to get it? Because the first step towards compliance with public records provisions is to understand that everything's defined as a public record. Too often we get very possessive. They're the First Selectman's records, you can't have them. They're the police department's records, you can't have them. They're P&Z records, you can't have them. Or we get selective. You look like a nice guy, we'll give them to you. You look very suspicious, we're not giving them to you. And you used to be a journalist, we're sure as hell not giving them to you. There is a temptation, folks, to deal with difficult people in a way other than you would deal with anybody walking in off the street. The first thing you want to understand is that everybody deserves the same treatment. Now we'll talk in a second about, not your obligations but also your rights, but understand that you want to treat with everybody the same way with the understanding that everything's a public record. I used to make up a little story to share with people about what not to do when people ask for records. But a few years back, the good city of Hartford gave me a real live example of what not to do, which I will share with you. The requester is a journalist, not a Hartford Current type journalist, but he does a blog and he has a public access TV thing going, and he's been around a lot when he goes to City Hall, and they're tired of him. They've had him enough and they're really tired of him. In this particular instance, he asked for two things. He asked for a record of bills submitted to the city by a law firm doing some work for the city, and a record of payment to that law firm. The Corporation Counsel's Office responds, I have your FOI request and will coordinate the response. Such documentation as is allowed or required by law will be provided. Now folks, the first thing to remember is when somebody makes a written request for records, you have 4 business days to respond. 4 days to respond, not necessarily to generate the records, because you may have the right to look at them, review them, find them. So this is what I would call a legitimate 4-day response. He's going to look for them. If you're going to do that, by the way, I would also recommend, if you can, some sort of a time frame for your requester. Look, you've asked us for thousands of pages here, it's going to take a while, or if it's 2 pages, you can have them come back this afternoon, depending on what the response is. So what makes this a good story? Well, what makes this a good story is that in the process of responding to this individual, whom he does not like, Corporation Counsel in Hartford accidentally copies that individual on an email he had written to an individual about how much he didn't like him. Everything is a public record. This one became more public because he hit the wrong button, but how many of us have not done that in our lives, hit the wrong button? So he sends this to the guy, and this is now in the hands of the journalist. Mixed company, I'll clean it up, but you'll get the idea. Carl, so who lit a fire under this? It's a bad word that starts with an A. If he's involved in litigation ongoing and or other projects that he hasn't asked about, can I shut him down? So his response isn't really, I'm looking for the records for him. It's, how do I get rid of him? Well, I told you the guy's a journalist. And he runs to his blog, he runs to the public access TV, and he's connected. It's on WFSB, it's in the Current. Hartford looks awful, terrible. Corporation Counsel tries to sort of apologize, but he can't do it. He hates this guy so much. In his letter of apology, apparently you have little else to do other than to pester me in this office and other city departments. Recall that I do not work for you. The purpose of the FOIA statute is not to provide you a playground. Folks, even if you think that, please do not write it. You now have created yet another public record that says, I don't like you, I don't like your FOI Act, and I don't like the requests that you're making. You're going to have days like that, folks. There are people who are not going to agree with you. Right now, the FOI Commission is struggling with an individual who last year filed 200 formal complaints against various agencies across the state. By far more than anybody has ever filed in one calendar year. And guess what? A portion of them are against the FOI Commission because he doesn't like what we've told him as far as not having a valid complaint. I want you to think about that for a second, by the way. Filing an FOI complaint against the FOI Commission with the FOI Commission. But anyway, but we still, when he comes in with a request...
That's not an inherent conflict?
What's that?
That's not an inherent conflict?
I guess, I don't know. We still have to deal with that, even though he's clearly at odds with us. He has the same rights, so when he makes a request, we have to deal with it the same way. When someone comes in and wants to inspect a record, the law says that you don't ask them who they are, you don't ask them what they want it for, what they're going to do with it. They have a right to inspect that record if it's not under one of those 3 E's. You also, however, have the right to find it. You have a right to review it, to make sure that perhaps there are things within the content of that record that you are able to redact, or that you have to redact. You are a board of education and there are student records. There's a federal law that says you don't give out certain things that identify kids, bless you. And the law says that you would redact that before you gave it out. Someone wants a copy of a record, you can then, that's different than inspecting a record, you can get them to put that request in writing. And that's when the 4 days comes in. But in either case, a copy of a record, inspect of a record, I can't stress this enough, I don't care what side of the fence you're on, no public agency has to drop everything to do this. A request for records under Freedom of Information does not mean immediate. I mean, it can mean immediate if it's an agenda that's sitting on your desk. You don't wait 4 days, you give it to them right away, but if it's something that requires review, requires a search to try to find it, you have a right to look at it and say, how long should this take if we're reasonable? The law uses the word prompt. The law says you're allowed to produce access to records promptly. Does anybody want to take a shot at what that might mean, promptly? Nobody really knew when the law was written. And shortly after the law was written, a case went to court to, what does promptly mean? The court says, we've got you on this one. Promptly means without undue delay. Well, it doesn't tell you a whole lot, but it opens the door for you to be able, as a board, as an agency, as an official, to interpret. Look, you've walked into the registrar's office 2 days before the election, prompt is going to be a couple of months. You walk in, 6 months after the election, prompt could be a couple of days. Depends on the season, depends on what's being sought, depends on what you have to look at. So always understand that you want to interpret the depth of the request, the amount of work it's going to take into putting the records together, and say, this is what's prompt in this instance. Guess what? The person making the request may not agree with you, but as long as you're in a position to say, this is why it's prompt for this record, this set of records under this circumstance, I guarantee you that you'll be fine. It doesn't mean you throw it to the side and say, because that is not prompt, and that would create an unnecessary delay. So you want to think about it, you want to realize what the right balance is, and go forward from there. As I said, when you comply with the records requests, what's hard sometimes is you don't know whether it's a record you're going to give out or not. You're looking at it and you're saying, okay, what do we do? Well, again, you have the right to review it. You don't want to take forever. You do it promptly. Just to back up for a second for the inspection part, if someone wants to inspect a record, it doesn't necessarily mean you give it to them and let them walk out of the building. I got a call from the police department today. It had a situation where there was a mom who was sitting in the waiting area, and the mom wanted to see a record. And the call to me was, is this a record we should let her see? And I explained that the exemption in play was a permissive exemption, which means it's a record you're allowed to withhold but not obligated to. And if they wanted her to see it, or they didn't have a problem with her seeing it, they could come into she could see it. And then the question was, do we just give it to her? And that's where I threw up the flag. I said, no, bring her in, and you sit with her while she looks at it, because you have a right to keep the record safe. So just because it's an inspection and not making a copy, and that may require some scheduling. So again, the promptness comes into play there. Look, we only have an hour to sit with you today. Come back tomorrow, come back the next day until you're done.
What about the whole scanning aspect? People come in with their phones or a portable scanner.
Well,
that's different than seeing it.
There's a provision in the statute that says you are allowed to use a handheld scanner to make copies for yourself. Now this is very interesting, because when you read the terminology in the law, it's very specific as to what the scanner, let's see if I can find it quickly, what the scanner entails. In fact, this was actually challenged in court. And the challenge came from someone who wanted to use a portable flatbed scanner. Let me see if I can find it quickly. But the law says that a person is allowed to, any individual may, I should probably turn it so I have to read it upside down. An individual may copy a public record through the use of a handheld scanner. A public agency may establish a fee structure not to exceed $20 for an individual to pay each time the individual copies records at the agency with a handheld scanner. As used in this section, handheld scanner means a battery-operated electronic scanning device, the use of which leaves no mark or impression on the public record and does not unreasonably interfere with the operation of the public agency. So a guy comes in with a flatbed, and a couple of clerks said, no, it's clear that they're talking about a wanding device. But as soon as this was written, the technology became obsolete. And many of us have these little devils, which are almost the same thing. So people call about that all the time, and I say, I honestly don't know, because the court decision specifically mentioned this wanding device. So here's my advice. Not in the law, off the record, it's not a ruling. If someone wants to do this, they have an app on the phone, like the way I threw that app out there, on the phone, and they can take a picture of it, take the $20, consider that a handheld scanner, and move on. It's just an easier way to do business. Now, if you challenged it, I think you might be upheld under those circumstances. But if you want to say, okay, we're going to let that stand for a scanner under these circumstances, and take the $20 and move forward, I think that's a good compromise.
But how about a record like you just referred to, that you said don't give them a copy, have them come in and look at it with you?
If they want to look at it, that's fine, but if they then want a picture, collect the $20 and I'm going to take the picture.
$20 a day, $20?
$20 a visit, good question. $20 a visit, yep. And it's not to exceed $20 for an individual to pay each time the individual copies records. So he comes in today, you take the $20, he comes in 2 days, you take the next $20. These fee structures, by the way, are not set by us. They're set by the legislature, so, yes, sir.
What if somebody comes in and they want to look at an employee's personnel file?
Okay.
What can be held back?
The problem with compliance with the records provisions are the 3 E's, and one of them is the exemptions. The exemptions are permissive exemptions. Section 1-210 of the FOI Act. Section 1-210 speaks to a lot of different records. I mentioned bids before. I mentioned attorney-client privilege. In that package are personnel files. And the law says that you are allowed to withhold records in a personnel file. There must be another meeting on it.
Yeah, probably not posted, but that's the regulations.
Not posted. Gotcha.
Let's give it a shot at Julie, when she was out of here.
Personnel file, so the exemption says that you are allowed to withhold things in a personnel file if releasing them would be an invasion of the person's privacy. The standard for invasion of privacy comes to us from a 1993 state Supreme Court case. It's called the Perkins decision. It involved a teacher who objected to the release of her attendance records. The Supreme Court said the attendance records of all of us who work in the public sector are public records, period, end of story, and must be released. The public has a right to know when we're at work. And then it said to have been an invasion of this woman's privacy, the release of those records would have to have been both, not either or, but both highly offensive and not a matter of public concern. It has to meet both prongs of the test. So if someone wants a personnel file in Clinton Town Hall, we'll assume that this gentleman is in charge. He looks at it and he says, would releasing this record be an invasion of this woman's privacy? If he believes it would, he goes to her and says, I think this is invasion of your privacy if we release it. If the person says, I don't care, out it goes. If the person then says, no, you're right, don't give it out, it can go out under no circumstances unless the person making the request files a complaint with the FOI Commission, and the FOI Commission says, Mr. First Selectman, with all due respect, you're wrong. There's no invasion of privacy there, give it out. Quick story, quick example. City of Middletown, situation with a police officer. There were rumors of things going on in the police officer's home that were not good. Bad things at home. Rumors got so strong that they put him on desk duty. And they decided, you know what, we can't leave him out on the street. They put him on desk duty. They did a complete, thorough investigation. They do this investigation and decide, you know what, he's having a lot of trouble at home, but it's having no impact at all on his performance. They put him back on the street. Hartford Current hears about this situation and wants to see the report, wants to see the IA report. Middletown PD says, you know what, there's too much about this guy's home life in there that's nobody's business. We're not giving it to you. We believe it's an invasion of privacy. The Current files a complaint with the FOI Commission. The FOI Commission says, too much about the guy's home life in there. It's not a matter of public concern. People were curious because everybody had heard the rumors. The public doesn't need to know it because it would be highly offensive to tell everybody about it. It's not a matter of public concern because he's doing a fine job. There's a disconnect between his problems at home and how he's doing his job. Not a matter of public concern, highly offensive to tell the world all his problems at home, complaint dismissed, it wasn't released. But it's got to meet both prongs of the test. And when a request comes in, it's always advised that you review, just to say, yeah, here it is, because there may be some things in there that can be released and some that should be withheld.
Yeah, I'd like to ask you another question.
Yep.
Is there no requirement, when somebody files a complaint, is there no requirement for them to give any justification, whatever, for the request?
A complaint to us? No. No, that's one of the things about the law. It's a record, period, end of story. If it's a public record or a public meeting, you file the complaint based on alleged denied access. It's up for our commission to sort of sort it out. We have the provision to, administratively withdraw them if they don't meet the right standards. We have a right to not schedule them if they're frivolous, but that bar is pretty high.
Okay.
The idea behind this law is to create a big tent for people to have access to their government.
So how about somebody that files multiple requests? When does that become
Well,
harassment, let's say?
that's a question for the agency to decide. If the agency decides that it's been harassment, that it's had enough, what it should do is petition the FOI Commission and say, look, we're being harassed here. We believe that these complaints are frivolous, that they are an abuse of the FOI Act, and then the commission would, act accordingly. But again, I need to tell you, because you want to remember when this law was written, the bar for something like that is very, very high. It's not what you and I might think is harassment might not rise to that level in the eyes of the law. Are there any questions about any other records, rather than go through them? Any records you want to ask about? Yes, sir.
I just have a question about down the road. Is there any inclination on the FOI Commission to start to, I understand public records are, you can have access to anything in the building, I get that, but with Facebook and Twitter and whatever, you get a flash mob of 1,000 people to show up at a shopping mall. I can get 1,000 people to file a complaint against a small town like Clinton, have one, it would just choke the system.
Yeah.
Is there any relief? Thought, not relief, but any thought down the road? And I understand that you don't want to have people justify why they get their records, because this is the United States of America, so.
One of the issues is that you run into constitutional questions, number one. Number two is that we only enforce the law that's given to us.
Right.
So that question would probably be best asked of your legislator. But from a position of people being overzealous, we are grappling with that. And the guy that I mentioned before has taken a tremendous amount of our labor and our time, and we're really trying to find a way to curb him. We've had multiple discussions about coming up with sort of a harassment clause or a burdensome clause. We have found that in recent years, people have found it to be very easy to make request after request after request. You would think that the act of finding an envelope and a stamp would not make it harder, but boom, 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 send, boom, 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 send, and the numbers in some instances are multiplied to serious levels. And people are not hesitant to be frivolous. They're not understanding that there's work to be done in town halls and state offices, and they're just firing away. And it does become a problem, but finding the right balance, because back to James Madison, it's very difficult.
Correct.
So the answer to your question is that tossed around? Is it talked about? Yes. Have there been any real serious steps in that direction? Maybe a couple baby steps, but nothing too concrete yet.
Nothing like, just as an example, to prohibit somebody who's incarcerated for the next 10 years on a...
The prisoners send us a lot of complaints too. And one of the issues is, they got a lot of time on their hands. And some of them are really...
mad.
And you should read some of them, or maybe you have. But they have the same rights. So that's been tossed around too. Maybe inmates should not have FOI rights. I don't know. Yes, sir.
Is there a time limitation on the keeping of the records that is hard and fast?
Yeah, keeping records, including your electronic records and things like that, is not in the FOI Act. There's a whole separate set of records retention laws in Connecticut. And if you have any questions about that, your town clerk probably has the whole package of what to keep and what not to keep and how long to keep it.
State librarian.
Yeah.
It comes from the state library, but they disseminate it all over the state.
In order to destroy records, you have to send a request to the state librarian.
And they'll tell you exactly how long things should be kept. That becomes a problem too with electronic records, because you keep your email if they have to do with business, and then how long you keep them, and then you run out of storage space and the whole thing. So I understand that too.
The problem is if you have taped, recorded meetings, and then you have the minutes, and the recordings, for whatever reason, are destroyed later because the...
But Mac, that's next one.
Yeah. There's a specific requirement for how long you keep those and when you can record over them and things like that. But again, that's not FOI.
Going to the time aspect, as far as the amount of resources it takes to put together some of these requests. There's always a discussion about what we can charge or cannot charge. We talked about the $20 for the the hand scan, when you have to take, say, our IT guy and he spends 6, 8, 10, 12 hours on multiple days to gather information on a request, is that billable? Is it not billable?
The only time you can bill for man hours is if producing something electronically requires formatting or programming. If it's just a matter of searching for records and pulling them out, you can't. So that goes back to when I discussed promptly. You've got an IT person, you've got other things to do. You look at the schedule for the week and you've got one of these massive FOI requests and say, it's only reasonable to expect him to spend an hour a week on that. And if it takes 20 weeks and that's what, that's your story and you're sticking to it, that's what it is. That's why you have to frame your response in terms of promptness, fairness, reasonableness, but also balance with what you need to do to get your job done.
And if a request requires a particular type of software that we maybe don't have,
You wouldn't be required to do that.
Okay.
You wouldn't be required to go out and buy it.
because we've had those instances.
Unless you're in a situation where you want to buy it and charge the person for it. You could do that. The person could be responsible for,
And what if they don't want to pay it?
well, then you don't buy it. You are not required
Like when
under
you produce the documents and they come in and say, well, no, that's too much.
Let's see, but you have to take a step before that.
Well, we do
You can
send
charge, you can charge up to 50 cents a page for a paper copy. Now, that may not seem like a lot, but that can add up, and if the cost of copying exceeds $10, you can get your money up front. The idea of, buying a piece of software, you're not required to do it. You're not required to scan in a paper document because somebody asked for it electronically. If you have it electronically, you should produce it. But format is kind of up to you. This happens a lot at budget time. I'm going to get it wrong, but the difference between a PDF and an Excel, and you have it in PDF and they want it in Excel so that they can play with the numbers, you're not required to do that. You're not required to change it over to another format. You're never required to create a record that doesn't exist. Many boards, many towns, many commissions, many agencies are asked for records that they don't have. Well, they could maybe put a couple together and make the record, but that's not a requirement. You're obligated to.
But if it's in Excel already, if it's already in Excel,
If they have it in Excel and there's no legitimate reason to give it in that, they could do that. But, if there's, sometimes Excel for people to play with numbers, there's a security reason or something like that, that might fit one of the exemptions. That would be looked at a case-by-case basis.
Like a budget sheet that's in Excel, we don't want somebody going to manipulate the numbers.
Yeah, that's an ongoing discussion. You give it in it talks about, see, the language isn't specific. It says you should produce it in the format requested if reasonable, if practical. So if it's not practical to turn it over in that form because you're afraid of, manipulation, then that would be the case. We have a decision that says that you're not required to put it, in the format that somebody requests, just as long as you give them the requisite information.
If you don't print it, it has to be free, or you can charge them for the media?
No, you can charge them for, the disc or the thumb drive or whatever you put it on.
It's electronic.
Right, it's electronic.
what about the cost of redacting?
Okay, if a record needs to be redacted, in most instances, the record has to be printed, in which case you could get charged for the pages. If it needs redaction, they could charge you the 50 cents a page for the redaction.
But nothing more than that.
That's correct. Not the time to redact.
So you can't charge for the time.
You cannot charge for the time, no.
So that if something comes in that's a voluminous request, going to be time on many levels for different personnel. It's just going to take as long as it takes, keep it within working hours,
Right.
no overtime,
Right.
no extra.
The recommendation there is just that, you keep it within working hours. Now, you get a big request, somebody wants a lot of stuff. You go to that person and say, look, this is gonna take 6 months.
Right.
If you want it faster, I can bring, these 2 people in on overtime if you're willing to pay it. Now, that's not in the FOI Act, but that's a deal that sometimes works.
Okay.
That's up to you. Any other questions or issues or anything you want to ask about? Different kinds of records, different kinds of meetings?
That's good stuff.
Anything at all? All right, look, I always bring party gifts. This is what I call the Freedom of Information American Express card. Don't leave home without it. It's highlights of the FOI Act. The print's really small, but we're a small agency, so we've got to make but they're very helpful for a wall at a desk drawer, a purse, something on the fly.
I saw mine from 9 years ago.
As important as what's in here, on the back, our address, our phone number, our website can be helpful. You go on the website, see past cases or things like that to give you an idea of how the commission has ruled before. Never, ever, ever be afraid to pick up the phone and call. You ask for me. Do I answer calls?
Absolutely.
Absolutely. I may not have the answer right away. I'm never afraid to say, I don't know. I'll get you an answer. Remember, just like tonight, it's not necessarily a binding legal opinion. It's something you can put into your equation as you try to figure out what to do. But never be afraid to ask. We're there to try to help. We don't want you to have to come up to Hartford for hearings. We want you to have FOI just sort of be something that you do as second nature.
They won't let me go to Hartford for hearings. The town attorney won't let me go.
Well, that's a different
There's a
story.
reason for that.
So we have those, and I also brought with me, and these can be helpful too. I'll leave a bunch of these. These are what are called a meeting cheat sheet. It's a grid that talks to you about noticing meetings, when to notice them, when minutes are due, and things like that. These can be helpful as well. Last chance. Any questions?
Is there any recourse if there's an agenda that promises coffee and it's not served?
Yeah, Mayor.
I can't speak to
I saw
that.
that. You're right. What the heck?
I can't speak to that. I'm not a coffee drinker.
So, I want to thank Tom, and I want to remind you guys were here when Tom came down 9 years ago. And Tom was brought to us by our good friend, Ed Hennick. Tom and Ed were friends up in Hartford, and Ed recommended to me to bring Tom down for the very first annual town meeting that I conducted as first selectman. And it was a great help then, and I want to thank you for
Just as,
doing
by the
that.
way, we were friends before Hartford.
Yeah.
I covered his son playing
Basketball.
And he was one of the resident troopers. My first job, I hate to tell you, was covering Saybrook and Westbrook for the Middletown Press back in Brookfield. And he was one of the resident troopers back then. So I knew him for a long time.
Yeah.
So they left us way too young.
Yep.
Way too young.
Yep. Thank you very much.
Thank you.
Thank you. I appreciate it.